I'm Attorney Zach Townsend. Of Pro Legal Care, I've been practicing family law, custody, and high conflict divorce or order of protection cases for over a decade. Vexatious litigant. It's a fun word, not a fun person to be around. A vexatious litigant is a person that uses the court system to harass you. A vexatious litigant is a person who files false motions, bogus pleadings, just to create a nuisance and to force you to defend yourself and to maybe create chaos or just to get their own way. A person that causes an abuse of the legal process to bully somebody. That happens through what's called vexatious litigation. So it can be overbearing because it's over and over and over, and then you have to defend it and defend it and defend it. Or it could be distressing because it's filled with lies and manipulation and things of that nature. So that's the type of thing that people are talking about when they say vexatious litigation. There are some very real struggles that you can have dealing with a vexatious litigant. The abuse of the legal process to cause harassment caused by abusers is prevalent, and it's a major issue. And the enforcement of it is very difficult because lots of people lie when they go to court. So unfortunately, it's very difficult for the courts to really figure out what's going on, and that turns some of these situations into the court just trying to try to wade through all this stuff and just get rid of it, instead of providing some justice to somebody who's actually using it for purposes of harassment. So one thing, of course, that you could do is file a motion to dismiss. If there's false information, and you could attach affirmative matter, such as a report or an affidavit that shows the truth, maybe a motion to dismiss can just get rid of it. And so what most people want with a vexatious litigant is just to have them go away. So that's what a motion to dismiss might be able to do. But of course, that's usually already, tried and tested and maybe happened. And that's the whole problem, is they won't stop even though it keeps getting dismissed. So if a motion or a case is dismissed with prejudice, it should not be able to come back again. And that is a basis to have it dismissed for good if they try to bring it back again. That's known as res judicata. It means you can't bring back the same issue because the thing has already been decided or adjudicated. One tool that you could use is a request for attorney's fees in that motion to dismiss, or in other motions. You could ask for attorney's fees, and the American rule is that each party pays for their own fees. But sometimes if the judge is fed up enough, they can make this person who's trying to bully you through the legal system pay your legal fees. One possible tool is contempt of court, because usually if someone's harassing you with the legal system, they don't value any rules or law or order, and so they're disregarding that, and maybe they can be held in contempt for disregarding the court's orders. You could also ask for court orders that provides rules or sanctions that require maybe page limits on future filings, or what's known as a pre-filing injunction. A pre-filing injunction is an order that bars the filing of a motion without leave of court or permission of the court to file the motion. So what a person who is subject to a pre-filing injunction would have to do is to file the motion with the motion they want to file attached as an exhibit, asking for permission to file the attached exhibit as a motion. And that requires permission then that way, and that's through what's called a pre-filing injunction. So you could request that, and that could also include parameters such as page limits, such as even formatting, or to not include certain exhibits, or to include certain exhibits as within the page count, for example. But what oftentimes vexatious litigants like to do is include private information attached to the pleadings as an exhibit, personal, maybe mental health records or something like that, something embarrassing to shame the other side, to cause them distress as part of their harassment. So they could be ordered. That person could be ordered to not include attachments of personal information, or that particular filing, if that did happen, you could request that the court order that filing, that petition that includes personal and maybe fabricated or false defaming information about you, to be impounded, which means that particular document is sealed. The best would be as if the entire case were sealed. That's rare because in our court system, there's usually access by the public to be able to sort of second guess the court system. That's why it needs to be transparent. So there's basically sunlight on everything. So nobody is unaware, and the public access is part of our democracy. And so that's why having a whole entire case sealed is rare, but it can happen in some extreme circumstances. Motion for sanctions pursuant to Illinois Supreme Court Rule 137 is also a possible tool to help prevent a vexatious litigant. Illinois Supreme Court Rule 137 says that every motion that's filed in Illinois courts has to be alleged in good faith, in fact, and in good faith in law. So any assertions that are knowingly false are sanctionable, or any assertions that don't have any basis in the law at all are sanctionable. And what sanctionable means is that they could be fined or dinged or punished, or maybe not so much. Well, it could be penalized, but often to just prevent the continued use of the legal system to cause this type of distress, or to make it so that someone has to pay for legal fees, or to miss court, or have to come to court, or have to answer these questions when there's just no basis for it at all. And that is when a motion that was filed was frivolous. Frivolity is a very high bar. It's very difficult to prove that and to show that it was so brazen and such a total disregard, then it might be found to be sanctionable. So it's pretty tough to get there, but there are some tools for when a pleading is filed for an improper purpose or for the purpose of harassment. That's what Illinois Supreme Court Rule 137 is for. So these are some of the tools that you can use to address somebody who's causing vexatious litigation or bullying you through the legal system. If you have someone who's bullying you through the legal system, we could help, and we could let you know your options. Set up a consultation with us, and we'll talk about your new path forward.